sounded to the bankruptcy people that were over there. The normally, if you think about $1 million claim, if somebody's coming bankrupt and they've got $1 million claim, normally what you're going to expect is that this is a person of wealth, or maybe a business that had some huge deal going on and somebody really screwed them out of the process. And you could understand how it could happen, but these are different. These are potentially multi-million-dollar claims that will exist in favor of debtors who, by all appearances, have no business with a multi-million-dollar claim. This could be a teacher at a school. This could be a mechanic at the Ford dealership. And they show up and bankruptcy court, and their filings show that they have no assets, or maybe very few assets, and they've got some kind of liabilities and maybe a lawsuit against them is what they will tell you about. And they're hidden in there these bad faith claims against an insurance company that are easily the biggest cases you may see all year long. And I think it's probably fair to say that many trustees have slipped and not recognized these claims, allowed them to either just kind of become abandoned or go by the wayside. And we're here to try to talk about how to stop that from happening. So first, let me talk about some nomenclature here. There is a concept of a first-party bad faith claim and a third-party bad faith claim. First-party bad faith, to have a big case for that, first party is you have an insurance company and you have an insured, okay, to just sort of follow where they're coming from. The insured, the customer, he's party number one. The insurance company is always party number two. So a claim where a hurricane loss or a fire loss, or these days you may have a virus loss with business interruption expenses, that kind of loss is known as a first party claim. The insured says, my damn insurance company owes me a fortune. They haven't paid me, or maybe they didn't pay me on time, and as a result of that, I've lost my whole business and I hate my insurance company. Well, that kind of claim is valid, but it's not going to hide from you. The insured is going to be acutely aware that he's got this claim. It's all he wants to talk about probably. And it's just going to kind of, it's not going to be easy, hard to spot it. It's going to be hard to miss it, actually. But Brent, if you could put me up there on our first party versus third party slide, I think it's slide one. There you go. The deal with a third party claim is this. So first party is the customer, the second party is insurance company, and the third party claim, what you have is an injured person of some kind who is out there suing the customer. These are liability claims where the customer is the one who is at fault. Your client is not the one who suffered damages directly. I'm sure your client. The debtor is not the one who has suffered damages directly, but somebody else has. And somebody else has suffered damages under circumstances that will give rise to a claim against this debtor. Now, the graphic that's up there involves a car wreck, just for convenience, but it doesn't have to be that. It can be any kind of a claim where a liability exists against the debtor. It could be a doctor, physician who's got a med mal claim that's overwhelming. It could be, God forbid, it could be a lawyer who's got a malpractice claim against them and somebody's coming after them. It can be what we would call a commercial general liability claim, like somebody's been hurt on a premises or some other thing like that. Any number of ways in which someone has sued the debtor under circumstance where there's maybe not enough insurance, and that's where it comes up. The idea of bad faith is in these third-party claims is driven by the notion that the insurance company has a fiduciary duty to their insurance. Insurance companies universally, the liability section of your policy, go home and read it tonight, and you will find that to get a liability policy, you have to give up absolute and complete control over the handling of that claim. They sell it like it's a product, a service, and it is, it should be, but it's also an obligation you have. If you have a wreck, if you have an accident, you have a legal malclaim by a client against you, and the first thing you have to do is report it to your carrier, and after that, you have to just stand by. Your financial future is in their hands. I've got a picture of the good hands. Your good neighbor, State Farm, they're holding your entire life, and there's nothing you can do without their approval to stop. If you attempt to settle that case or inject yourself into negotiations, if you even get deeply involved in an investigation of the loss, that can be a violation of your policy, and now you lose all your rights if you do something like that. And so because they demand that control, and they always do, because they demand that control, as long ago as 1938, in a case called Shaw versus Auto Mutual, the Supreme Court of Florida and most other states too, say, look, you got to exercise that power, insurance company. I don't care what the policy says. The policy says we will settle or defend as we see fit. That's always the give themselves. But the can you? Are we? Don't screen share me for a minute.
I'm not.
All right, perfect. Brent's got controls over the. I'm like in the passenger seat on an icy road here. This is tough. I don't even remember what I was saying, but they have the duty of good faith that arises out of their control. Is I guess where I was trying to get to. And so, because of that, they've imposed everywhere a fiduciary duty that arises. And so that duty is to settle a claim if the opportunity presents itself, when under all the circumstances they could and should do so if they were acting fairly and honestly and with due regard for the interests of their insureds. And so the claim that you're talking about is not one that belongs to the injured person. The injured person, everybody hates the insurance companies, and the injured people want to settle and they're griping. There's no duty owed to that injured person under your liability policy. The duty, the only duty, is owed to the customer, the one who's paid the premiums. Now, ironically, the customer frequently is kept in the dark. They're not supposed to be. The insurance company is supposed to be advising them at every step along the way, but that never, almost never, ever happens. And so as often as not, they'll come to you and they file bankruptcy because they've been told there's no hope. You know, your case was too damn big. I'm sorry, you know, you've killed a child with your automobile and you only had $100,000 of insurance. There's just nothing we could do. You can't get 5 pounds of sugar, you know, out of a 3-pound bag. And so the insured understands that logic, and off they go. But that's not normally how claims are handled. If you've been around personal injury claims, you know that the initiative is always to attempt to settle the claims. And people are smart enough, plaintiffs' lawyers are lazy enough to where they're not usually going to be chasing after assets. They know better. Any of them that have ever tried it have learned that that's just a fool's errand to try to chase down an insured, unless their business or very wealthy, trying to chase down an insured to get excess assets after a judgment's been entered, and you're not going to do it. And so there's always the effort is to settle the case within policy limits. And so you may ask, how did this ever happen then? If they're always willing to settle, how does it ever happen that that doesn't happen? So take a look at their, this is our standard instruction. So our standard instruction is fairly, and this is from the Supreme Court, but it's sort of been incorporated into a statute, but it's the standard instruction that's given in every case, and it's been around since at least the early 70s. Rises from a case called Boston Oak Colony versus Gutierrez. And just what I said earlier, that language, failure on the part of an insurance company to settle a claim when under all the circumstances it could and should have done so and it acted fairly and honestly or due regard for the interests of their insured. So let me just talk for a minute about how this comes up. So that, if you look at it, that's a pretty solid standard right there, man. Imagine that you're hit with an excess judgment and you're suing your insurance company for failure to settle, and they had a chance to settle and didn't do so. That standard is fairly consumer friendly, isn't it? Yeah, a buddy of mine named Left, maybe, who's no longer with us, tried 43 of these cases in a row and never had the pleasure of hearing a jury tell him no. Every one he tried, 43 comers, every one of them was a success. But the way these cases will present themselves, as often as not, how does this happen? Well, there's two, generally speaking. The first ones are the evolving claim type. And people don't look that badly hurt at the beginning of the case, and then it just gets worse and worse and worse. You know, they come in, they've got a broken arm. There's $100,000 of insurance. Seems like plenty. They offer $50,000 or $60,000 for the broken arm, but then plaintiff says, "I want $100,000," and that sounds like it's a manageable situation. But then there's an infection in the procedure, or the plaintiff develops a secondary condition like RSD or something like that goes wrong, and all of a sudden that claim becomes $1 million claim. Now, the insurance company has not committed bad faith if the facts that are available to them don't reveal that this is a $100,000 claim. They haven't met the standard. But if the you can stop that screen share, Brett. Just leave it just like that. But if the circumstances are that after the case got worse, the insurance company had the information available to them. Maybe they didn't even know about it, but they should have known about it. In those evolving claim situations, the time passes when they could settle the case. And if they've had a fair chance when they knew about it or should have known about it, they didn't then come forward with their policy limits, and the case results in being a $2 million verdict. That's kind of a way, an uncommon way, but a way that you'll see a bad faith case. Generally speaking, an evolving claim case is not going to be the biggest cases that you see, because few people have that drop off where all of a sudden they seem like they're doing pretty well, they're on the mend, and then something goes really wrong. Much more common, much more likely is the catastrophic injury, where for a variety of circumstances, an insurance company just fails to settle. You'd think they'd never do it. You'd think they can't be that stupid or they can't be that lazy. But that's because you don't deal with insurance companies forever. Talk to your buddies who do. So you'll have a quadriplegic case, a kid hit by a car, and the car's got a 100 policy or a 50 policy, or dang it, it'll have a $10,000 policy. It doesn't matter. And the plaintiff's lawyer is in the position where he's got to recommend to his client, this catastrophically injured person, who's going to have a $3 or $4 million cash need over the rest of their life to make up for their injuries and pay their medical bills. He's got to go explain to this person that there's really nothing we can do except take the $50,000 policy limits. In order to do that, he's going to have to do some due diligence, or else the case may end up being against him or her. So a typical situation is that plaintiff who makes the settlement offer, or who is discussing the settlement offer, that plaintiff will tie to it as conditions to the offer. They will tie to it, I'm going to need to see an affidavit that there is no other coverage, an affidavit as to where your insured was coming from and where they were going to make sure that they weren't in the course and scope of their work. If they were drinking, I need to know where they were drinking, and I may need to investigate their history of drinking to see if you've got a dram shop case here. I've got to foreclose these possibilities, is what the plaintiff's lawyer is saying. Is he knows, she knows, forgive my use of the male, I mean nothing by that, just don't. She knows that the best way to get that information from an insurance company or from the insured is to tie it to a settlement offer. So I will settle with you within 45 days if you produce this catalog of information or perhaps documents. Insurance companies historically are just not geared up for that. And so they may come up with the money, they'll come up with the $10,000, whatever, but they're not going to meet these other conditions. And plaintiff's lawyer's out there and she says, this is nice that you've offered the money and it's nice that you gave me sort of a inconsequential affidavit, but you have not complied with my settlement terms. And off they go. So you say, really? And that's enough? That's enough to make the insurance company liable to pay the entire claim? Well, I'm getting ahead of myself here, but think of it like this. This isn't a fight between the injured person or their lawyer and the insurance company. It's not. This is a fight that's going to occur because what happens when the insurance company doesn't meet, assuming that they're reasonable conditions, not make-believe nonsense, assuming that they were reasonable conditions and they were tied to an express opportunity to settle this huge case, and the company fails, what happens next is maybe the plaintiff decides, I'll give you another chance and we'll give you an extension of time. Maybe they do that once, but that's the end of it. They give you two chances, and that's the end of it. Now they take the case and they go to trial. When the policy limits are offered or the affidavits are later submitted, the plaintiff is under no obligation to take them. Plaintiff goes to trial and the plaintiff gets a judgment, and the judgment's for $15 million. Well, the fairness here is because that insured, who perhaps has, $500,000 of assets, or perhaps it's a business that they worked on for their entire life, hoping to hand it down to the next generation. That business is now faced with a situation where the claim could have been settled. It should have been settled had the insurance company discharged their fiduciary obligations. And instead, they're going bankrupt. And how do you avoid the bankruptcy? There's only one way: pay the judgment against them, or negotiate it, or pay it against them. And that's how bad faith cases become so powerful. It is the claim by the insured, and it is not measured by what the insured lost, not measured by the assets they had, because, follow that through. Let's say the person had $10,000 in the bank. And so the injured plaintiff takes that $10,000 and the judgment's still out there. So the next $10,000 they get, he'll take that too. There's no other way to measure the damages except by the size of the judgment. And the impact is to the insured's credit. None of us would have a problem if we're thinking about a legal malpractice claim and a lawyer screwed up like that, and a lawyer hurt their client in that way. We would all understand that that lawyer was on the hook for those damages. Well, it's no different for insurance company. Their duty, while they are protected from ordinary negligence, they are the only business in Florida, and our legislature in its infinite wisdom and the courts have said that insurance companies are allowed to be negligent, and even if their negligent causes their customer to go bankrupt, the very person whose premium dollar is paying their salaries and their year-end bonuses, if they are simply negligent, they just get a free pass. But while they get to be negligent, on the other hand, they do not get to violate this very strict, very high duty of fiduciary duty. And it is compared to, in the cases, that of attorney-client. Now, as often as not in these cases, the reason they're so hidden is because the insured is kept in the dark, as I was saying. He doesn't know. He doesn't know that there was this preliminary settlement offer. They're supposed to share with him, but often they don't. Time limits go by before they realize, oh, geez, what are we going to do now? Should we tell the insured? Hell no, don't tell the insured. You know what they're going to do if they find out about this? Let's see if we can find some other way out of this before we go stirring the pot, letting our insured knows what happens. And so what the insured will know as often as not is, sir, we tried to settle, but we could not. Or maybe they'll say, we tried to settle, we offered the money. The claimant wanted a bunch of conditions that were impossible for us to meet. They did it on purpose. They tricked us. They trapped us, hoping that you would sue us or something like that would happen. But We've run this past all of our lawyers and they all agree we did nothing wrong. So there's nothing we can do. And I'm sorry, there's nothing that can happen here. So how do you spot it? If your own bankrupt doesn't know that she has a claim, how do you spot the claims? Well, there are patterns that these things will follow. And let's put this slide up here. Got me ready?
So,
All right, hit a click. So the first thing that you're going to know is that if you find somebody who's in bankruptcy because there was a lawsuit or a judgment against them, that should never happen. Honestly, that should never happen. Uh, there will have been a settlement opportunity. There will have been some reason. Now, I say a settlement opportunity. Let me just clarify that one thing. You may look into it and find out. Heck, the plaintiff never offered to settle for the policy limits. He never said one way or the other. Next thing we know, probably 90 days of silence, 120 days of silence from the plaintiff. Neither side was talking. And then first thing we hear about it is a summons and complaint. Sheriff's out there knocking on the door. Well, it doesn't have to be for there to be bad faith. There's an old case called Powell versus Prudential, and it's been affirmed by the Supreme Court recently. That says, you get these situations where you have a claimant's lawyer and you have the insurance company, and neither one of them wants to make the first move. They're like eighth graders at the school dance, all the ladies are lined up on that side and the boys lined up on this side, and they all want to dance, but they don't want to ask the other one because what if they say no? And so the courts have been clear about that. The courts have been clear that the obligation to initiate settlement discussions rests with the insurance company. So there should not ever be a bad faith claim. Plaintiff's lawyer, it should not ever be an excess judgment. Plaintiff's lawyers are typically not going to pursue the claim unless something has triggered in their head that the insurance company failed on a duty. Second thing that you might want to see here is that the lawyer, the lawyer who defends the insured is representing the insured only. That's the professional relationship, but they are paid by the insurance company. They are selected by the insurance company. They report to the insurance company, and while you can say they're not controlled, they have independent judgment. They don't have any money to go hire experts. The insurance company has that. They get griped at if they spend too much time on the case. The insurance company controls that. And so the relationships that develop between defense lawyers and huge law firms is often very cozy with the insurance companies who hire them. That is, by real life, that is their bread and that is their butter. And they may see this insured one time, their client, they'll see him one time, but they'll deal with the insurance company adjusters hundreds of times. So it's a little awkward whenever the insurance adjuster has messed something up that might give rise to a claim by the client versus the people that are paying the bills. And so often you'll find that the lawyer hired by the insurance company is the one who recommended to the debtor to file bankruptcy. Many of these defense lawyers still think that if they can just do that, if they can just get this fella discharged from the claim, that'll be the end of this nightmare, and that'll be his ace card that he can play. Brent and Stephanie will explain that's not true at all. The claim becomes your claim as trustee if you're the trustee. So let's click on the next one, Brent. Another telltale sign is that there's issues about coverage. If you look into it even a little bit and you find out that maybe somebody had coverage denied or there was a policy violation claimed, a late report. Many insurance companies make their living on raising defenses. I could tell you 100 war stories about this, but one case, a 15-year-old kid took the family car out and caused a horrible accident. They said, well, do you know how to drive? And he says, I don't know. Let's try it. And so he went out and called the wreck. In that case, the insurance company said, you listed all the drivers in your household when we wrote this policy, and you didn't list this young man. And they said, well, he was only 14 years old. He wasn't a driver. Well, he clearly was a driver, even though he wasn't licensed. And they raised that as a defense. Any defense like that, any curiosity, late reporting, failure to cooperate. And I won't bore you with these stories, but that defense lawyer, we have seen situations where they help build the failure to cooperate case, where they're reporting to the company, I've tried to call my client, and he won't call back. And so I don't know what else to do. I'm getting no cooperation, knowing that that's the magic language to screw his insured, his client from the insurance company. And so if there's a coverage issue that's been raised, double check on that, because again, plaintiff's lawyer wouldn't be pursuing it if there actually wasn't a pretty good solid case for coverage. If the debtor is confused about the process, really doesn't understand what happens, that's probably a good reason right there. I don't know why they want $3 million. I don't have that kind of money. I'm a teacher. How am I supposed to raise $3 million? But we went to a big mediation thing, and that's what they said they wanted. And they shuffled me out of the room, and I didn't get to hear exactly what was going on, and nobody's explained it to me. Bad faith every time. Bad faith. The other one that you'll find is everything is running wrong. It's like a no asset case. And some lawyer from an insurance company will just out of the sky drop in, and she will want to offer some nuisance money so they can close their books. We had a case in Jacksonville, was it, Brent, where there was a multi-million-dollar judgment entered against a fellow who I believe caused a paraplegic injury. And the debtor went bankrupt, which happens, and everything was proceeding normally. What we did not know is that behind the scenes, the insurance company went and talked to the trustee and was saying, look, we have to close our books because this was our fella and they didn't take our money. We had $100,000 policy. I don't know if that was the number, but how about we offer $200,000 just so that we can bring this thing to a close? Debtor's going to get a discharge anyway. That should wrap it up. That's an eyebrow raiser right there. Insurance companies do not give away money just to sort of clean up their books. And so that's all. These are situations whenever it's probably time to have either you or the general counsel, if you're trustee, or if you're the debtor's lawyer, before it ever goes anywhere. All those are good opportunities to say we ought to talk to a bad faith lawyer. Okay, Brent, I think you could, and I'm afraid I'm hogging my time. Huh?
The first party.
Well, first party went down there. Yeah, don't worry about that. That's that situation where you're not going to miss that claim. That's the claim by the insurance company.
You want to touch this and move on? Or?
No, I think, I've said enough to give you an idea about what the basics of bad faith are. Okay, the basics of bad faith in the context we're talking about is a third party claim where the debtor is the one who's screwed up in some horrible way to get themselves sued. Number one. Number two, there was liability insurance and the case did not settle. And it either has resulted in a big verdict against them or resulted in they're heading to trial and they're trying to get out of going to trial, or their lawyers referred it to them. Those are the situations where you're going to see it. Breach of the fiduciary duty to settle. The duties are that their obligation is to investigate all claims fully before settling any. Don't give the money away. Number two, they have to affirmatively initiate settlement if liability is clear and the damages appear high. And number three, they have to settle the case when under all the circumstances, a reasonable person would do so. How hard do they have to try to settle? If the plaintiff's lawyer, she threw up a zillion different conditions. Does the insurance company have to jump through all of those? The standard's pretty easy. The standard is, what would a reasonable person stand in the shoes of the insured do to avoid this entire liability. So when we say there was a $100,000 policy and that the plaintiff made it very difficult to settle, and sometimes they will, they'll be very careful. And sometimes plaintiffs are hoping for bad faith. That's like, that's supposed to make them immoral or something, that they hope that the enemy in their lawsuit screws up. I believe every lawsuit I've ever been near, each side hopes that the other side screws up. That is their aspiration. That is their gift that they're hoping for. Hope the other side throws an interception. Hope they fumble. And so maybe they made it very difficult for them. How hard do they have to try? Imagine that it was their money on the hook. Imagine that the $10 million liability was directly against Geico. And that for whatever reason, Geico had a chance to settle it for $100,000, but only if within 45 days, they gathered up 15 different affidavits and documents and other things. We reckon Geico would do that to save their own $10 million. I reckon they would. That's the standard, how fiduciaries work. They put themselves in the shoes of their beneficiaries and they act with that same level of care and diligence that they would. So that's the basics of it. Brent Steinberg, I'm supposed to introduce him. Brent Steinberg is a partner in our firm. He runs our appellate operations. He is, we call him the brain trust of his group over here, because when we don't figure things out or we screw up, Brent and his team are the ones that save us. So and I'll go ahead and introduce Stephanie while I'm here too. Stephanie Miles will finish up on this. Stephanie is one of our frontline trial lawyers, has extreme, I can't say like for Brent, his first week he was admitted to law, to practice. His first week he was admitted to practice, he got a verdict over $10 million. Not many people can say that. But Stephanie can say that she's been involved in dozens of multi-million-dollar cases that resulted in bad faith cases and handling the bad faith cases herself. So those are my partners that'll be taking it from here. So Brent, you're up next.
All righty, bear with me one moment to get situated here. If you saw earlier where I had on the screen legal malpractice, that was just as a little reminder that if there is a lawyer involved in the fair to settle, then there very well could be a legal malpractice claim. And it works very similar to the bad faith claim, is that the lawyer would be getting sued instead of the insurance company. We have a pretty lengthy PowerPoint, which we're definitely not going to get through, but it has lots of citations to case law and the various jury instruction standards and whatnot. And we will forward that to Andy at the end and make sure that it gets distributed to y'all appropriately. So let me just talk about, I'm going to switch gears and talk about how these fair to settle claims work in the bankruptcy context. And of course, as Dale said, the debtor gets discharged and their personal liability is gone. But the most important takeaway from today's presentation is that it doesn't wipe out the bad faith claim. And that's a question we get frequently asked. And let me just go into some depth about why that is to make sure that you all understand where we're coming from here. And so everything really starts with a case called Camp. And I'm going to go walk through it in some detail because I think it will help y'all understand how this works, bad faith in the bankruptcy context. And it's a little complicated because there were 4 appellate decisions in total. So let's start with the first one. It was a trial court case. There's a surgeon who's getting sued for medical malpractice. The injured patient, the claimant, had offered to settle with the doctor for their $250 liability insurance limits multiple times. And while the case is ongoing, the doctor files for Chapter 7 bankruptcy. The doctor gets discharged, but then the stay gets modified to allow the plaintiff to go liquidate his damages in the trial court injury or medical malpractice case. And it ends up with a $3 million judgment against the doctor. But of course, the doctor isn't personally liable because the doctor had been discharged in bankruptcy. Well, then comes the bad faith case. And it's against St. Paul, which isn't a Florida citizen. So it ends up in the Northern District of Florida on diversity. And they're addressing something at the time was an issue of first impression of what happens. How does the discharge affect the bad faith claim? And the Northern District says that because the doctor had been discharged and relieved of any personal liability, and there was no bad faith claim against the surgeon's malpractice insurer as a matter of law. So that gets appealed up to the 11th Circuit. The 11th Circuit says, oh, this is really an issue of Florida law, so we're going to kick it to the Florida Supreme Court on a certified question. And that's how we end up with the Camp decision. And the Camp decision holds that the insured's bankruptcy does not bar the bad faith claim by the bankruptcy trustee. So how does it get there? Well, it says that the estate, bankruptcy estate, is comprised of all legal or equitable interests in the debtor, of the debtor in the property as of the commencement of the case, as I'm sure you all know better than I. And then it says, including any potential or contingent claims. Well, so after the Supreme Court case, it goes back to the Northern District of Florida so that they can go back to the bad faith claim and have the jury decided on the merits about whether or not the insurance company acted in bad faith. And they went ahead and made that determination. Jury finds that the insurance company acted in bad faith, and the insurance company appeals. Goes back to the 11th, and the 11th says, in the 11th, the insurance company says, well, the Florida Supreme Court, they're really misinterpreting federal bankruptcy law here. That's not how it works. Section 541A isn't applicable because the bad faith claim hadn't accrued yet. At the time of the bankruptcy, there was no bad faith claim because under Florida law, bad faith claim only accrues when there's a judgment that's actually entered. And, the doctor had filed for bankruptcy before a judgment had been entered against him, before there was even a trial. So how could it possibly be that the bad faith claim doesn't get wiped out by the bankruptcy, by the filing of the bankruptcy? So it gets appealed, and that's the argument they make at the 11th. And the 11th, in a case called Venn, the same case, holds that the Florida Supreme Court precedent is binding under the law of the case doctrine. But then it goes on to say that regardless, interests in property are creatures of state law. So if the Florida Supreme Court says that a potential bad faith claim is property, then we're going to say it passes to the estate. If that's a little confusing, let me just try to back up and just give you the 30,000-foot view takeaways from the Venn and Camp line of cases. And it's this. It said an unaccrued bad faith claim passes to the bankruptcy trustee. And the insured's bankruptcy doesn't allow the insurance carrier off the hook, as we've been saying. But another important takeaway is that the insurance company owes a duty of good faith not only to the insured, or I guess it ends up being the debtor in this context, but also to the bankruptcy trustee. And why is that important? Because the bad faith can occur before, during, or after the bankruptcy filing. It's in the entire course of conduct. The insurance company's entire course of conduct is relevant and is going to be considered under the totality of the circumstances standard. And if the insurance company fails to settle on the bankruptcy trustee's watch after they're substituted in, then there's still a bad faith claim. The Supreme Court said that the trustee acted properly in filing a bad faith claim to recoup the excess judgment for which the estate remains liable. So there's nothing nefarious about this. The trustee is obligated, I would argue, fiduciary obligation to ensure that all of the estate assets are properly pursued, including any bad faith or potential bad faith claim. And the recoverable damages, as Dale said, is the entire excess judgment plus prejudgment interest. And in Venn, they actually talk about the prejudgment interest specifically, and that can be pretty significant when you're talking about a $3, $4, $5 or more $1 million claim. The interest ends up being really substantial. Now, the bad faith claim, it belongs to the bankruptcy trustee. I'm going to skip this slide in any depth, but I just want you all to know that there is also an argument that the injured plaintiff, the one who was suing the debtor initially, can stand in the shoes of the debtor, the insured, to pursue the bad faith claim, particularly if the trustee ends up not pursuing it. But it is a question of Florida law that hasn't really been fully directly addressed. I think that the injured claimant can probably bring the bad faith claim, particularly if the trustee doesn't. But in Camp, without addressing prior Supreme Court precedent, they suggested that wasn't the case. So let's just say it's unsettled and leave it at that. Now, about this whole process on liquidation of damages, and what exactly is supposed to happen? How do we get from the point where you've got your doctor who files for bankruptcy to now the trustee having the bankruptcy, the bad faith claim to pursue after the bankruptcy is finalized and the doctor's discharged? And the case that best describes what happens is the second DCA case called Rittenauer. And just as background on here, I think will help give some context. So the insured defendant filed for bankruptcy when the personal injury suit was still ongoing. The plaintiff gets relief from the state to liquidate the damages, just like in the Camp case I talked about, and the trial court entered summary judgment in that injury case in favor of the defendant, saying that no matter what, the plaintiff's recovery has to be capped at the policy limits because the debtor's been discharged. So I don't remember the limits, but it's just, say it was $100,000 limit. Even if the plaintiff's damages was actually $1 million, we're saying that as a matter of law, they can't get more than 100,000 because that's what the limit was. And that would obviously only benefit the defendant's liability insurer because they're the ones who would stand to lose if the bad faith claim was pursued. The defendant debtor had been discharged. And the second DCA saw what was going on here, and they reversed the trial court's decision capping the damages. So the plaintiff's entitled to have the full extent of the damages determined by the jury. Here's a quote. But essentially, the tortfeasor's bankruptcy filing and discharge doesn't change the procedure. What happens is what happens in every other case. You've got a jury trial, if it gets there, where the full extent of the damages are determined. The only difference is that after a final judgment is entered against the debtor, or I guess the trustee standing in the shoes of the debtor, it then becomes the trustee's responsibility to pursue the bad faith claim. Now, I mentioned legal malpractice, that oftentimes these failure to settle claims will involve some legal malpractice component if the insurance company hired a lawyer to basically do its job for them. And it's an interesting question about whether it should work the same way in legal malpractice context as it does in bad faith. Of course, the federal law determines whether an interest of the property is a bankruptcy estate, but the state law determines whether the legal malpractice claim existed at the time the debtor filed for bankruptcy. And the general rule is that if the malpractice claim existed prior to or contemporaneous with the filing of the bankruptcy petition, then it becomes an estate asset. So, does it work the same in the legal malpractice context as it does in the bad faith context, like we talked about in the Camp case? And the case that talks most closely about this is a case called Herendeen, I believe, second DCA case from 2017. And there the court holds that the discharge of the client judgment debtor doesn't extinguish the trustee's cause of action for legal malpractice, citing the Camp case. But I don't know that this case resolves the issue in all cases, because in the Herendeen case, the petition for bankruptcy was filed after the judgment had been entered. I think it might be a little trickier question about whether the malpractice claim becomes an estate asset if the claim or the petition for bankruptcy had been filed before the judgment had been entered. What if the lawyer negligently fails to settle pre-petition? Is essentially the question that we're asking here, but the damages are only suffered post-petition. And another way to ask it is the question that they asked in Camp. Would the Florida Supreme Court recognize that a potential legal malpractice claim, like a bad faith claim, is property of the bankruptcy estate? I think they will. I think they should, just like in the Camp case. It's kind of hard to distinguish logically between the two, but it's somewhat of an unsettled question. But I mean, it's got to work that way, because otherwise you've got a lawyer who can commit malpractice, then get his client to file for bankruptcy so that the lawyer can save himself. Presumably the court wouldn't let that fly, but as I said, it hasn't been directly addressed. I'm going to touch on privileges real quick, because a lot of time in these bad faith cases or failure to settle legal malpractice cases, privilege fights are huge. The claim file of the insurance company and the internal documents that they all claim are confidential is really the main source of evidence for proving that the insurance company acted in bad faith. And it's not really an issue when it comes to work product, because Florida law is clear that in the bad faith case, the insurance company isn't allowed to assert work product objections over their internal documents. But it's a little thornier of an issue when it comes to attorney-client privilege. And the general rule from a case called SCOMA, which was actually Dale's case, I believe, right?
Yes, it was.
The general rule is that a person does not waive or otherwise lose an attorney-client privilege merely because a third party is authorized to file a lawsuit against the person's insurance company. And the question for in the bankruptcy context really is, well, is the trustee considered a third party for purposes of privilege? Now, I don't think they should be. In Camp, the court says that the bankruptcy estate stood in the shoes of the debtor and in effect became the insured debtor. So that certainly doesn't sound like a third person. And of course, when you've got a corporate debtor, the attorney-client privilege automatically passes to the trustee. But the law is a lot more unsettled when you've got an individual debtor. When you've got that doctor who filed for bankruptcy, does the doctor's attorney-client privilege with the doctor's defense lawyer appointed by the insurance company and all the communications between the insurance company and that lawyer, does that privilege pass automatically to the trustee? That's the question I'm asking here. And there's a split in authority. I can go into more depth, but we're short in time. I'll tell you that, with all due respect to Judge Glenn, I think number 3 isn't the correct view of the law, but it's unsettled. So the best thing that the trustee can do, or that the trustee's lawyer can help the trustee do, is get the debtor to sign something like this, an authorization for information or a waiver that says to the insurance company and to the debtor's former lawyers, hey, give all of my privileged communications to the trustee, and I leave it to the trustee to waive my privileges as the trustee deems appropriate. This is a form that we're going to give, along with some other forms, we'll give to Andy for distribution at the end, and hope, maybe you can put up on your website or whatever. So don't feel compelled to try to jot that down. Last thing I'm going to touch on before I turn it over to Stephanie is the duty to cooperate. Now, the trustee, the debtor has a duty to cooperate with the trustee. So arguably, the debtor would be required to execute that authorization I just had up on the screen so that the trustee can gather up the evidence that he or she needs to try to determine whether or not there's a viable bad faith or legal malclaim and ultimately win it. And that duty should extend to special counsel. But I think it's a fair question to ask, how much is really required of the debtor? That they've been discharged from personal liability at this point. Does the debtor have to participate in the bad faith claim? And I think that you got to kind of look at this on a case by case basis. These are really document intensive cases. Quite frequently, we don't really need the debtor to testify. If there was a communication failure where part of the bad faith was caused by the insurance company not properly advising the debtor of the possibility of an excess judgment, or as Dale said, not telling the debtor even that a settlement offer was made, or that perhaps the debtor had to provide an affidavit that they had no other coverage, something like that. In those circumstances, the debtor might have to testify. But by and large, most of the bad faith cases aren't going to be completely dependent on the debtor's testimony, and often can go forth without the debtor participating really at all. It's the trustee who owns the claim at that point, and the trustee can generally get it done without the debtor's cooperation. But as the trustee, it's important for the trustee to remember, particularly if it's the trustee getting substituted into the underlying personal injury action where the debtor files for bankruptcy before a judgment, that the trustee has a contractual duty to cooperate under the debtor's insurance policy. Because remember, as the Camp case said, the trustee effectively becomes the insured. So whatever duty the insured owed under the policy to cooperate with the insurance company, that duty gets passed on to the trustee. Under the policy, the liability insurer, even after the filing of the bankruptcy, remains in complete control over the settlement and defense of the case. So the trustee can't go settle the liability claim, the underlying personal injury case on their own. General rules, trustees should let the insurance company and the defense lawyers do their thing and just stay out of the way. But overall, cooperate. Otherwise, you can end up voiding coverage. So that's my spiel. I'm going to attempt to move the camera wrong way to Stephanie, who's going to walk you through some of the more practical tips about how these claims get processed.
Hey, good afternoon, everybody. Yeah, so I'm Stephanie, and I'm all about practical application. Knowing all the law is wonderful, but when it comes to the realities of your bankruptcy practice, how do you take that information and apply it? And so, I mean, the best news of all is that there aren't any cons. If we're to talk about the pros and cons of a trustee pursuing an insurance bad faith or failure to settle legal malpractice claim, it can take a long time, like anything else. But Chief Judge Delano has held in the Kwiatkowski case that even if you don't have Mr. Maybe's 44 bad faith case win streak, or you don't have Mr. Swope's 20-some, 30-some insurance bad faith win streak, that even if the trustee pursues that claim and loses the bad faith case, the chief judge has held that that doesn't become an obligation of the debtor. So that isn't something the debtor is going to have to worry about paying attorney's fees or costs back to the insurance company for pursuing the bad faith claim. So pros, low risk, high reward, that there's no cons. The bad faith attorney that the trustee is going to hire as special counsel is typically going to do so on a contingency fee. So they advance all of the costs, and much like personal injury cases, if there's no recovery, if there isn't a successful insurance bad faith claim, then no fee is owed. Talk about the nuances of when the bankruptcy is filed versus when the underlying judgment becomes due and owing. Once the underlying case goes to trial and the final judgment is entered, at that point in time, the policy limit can be collected, and the insurance company is usually going to pay that. The only time that doesn't happen is if the case goes up on appeal, and you've got to wait for it to come back to the trial court before the insurance company will say, okay, now we'll pay our policy limits that are due. But once you win the bad faith case, you get a yes on that was the insurance company failing to settle the case when they could have and should have, then you get the full value of the claim. That's what comes into the bankruptcy estate. So if it's a $3 million verdict on a $10,000 policy, you're talking about the full $3 million. And the other thing that's really kind of a pro for the debtor and the debtor's estate is that you stop the personal injury creditor from pulling money from other creditors. So if the bankruptcy estate does have, credit card collections that put the debtor into bankruptcy, potentially they can get paid as well from the recovery of the bad faith case. So talk about the process, and really I probably will go out of order with the slide a little bit, but there's sort of two hats that as a bankruptcy practitioner you're going to wear here, where you'll either receive the call from the underlying plaintiff lawyer who isn't sure what to do because they received a letter in the mail from the bankruptcy court saying their defendant debtor is now in bankruptcy, or you're going to be representing the trustee who could be faced with this potential bad faith claim at sort of any point in time in the claim. So let me talk first about the plaintiff lawyer who's going to call you asking what to do. You need to make sure that they understand that they've got to schedule the claim, that they need to file the value of the bad faith claim or what is going to be a final judgment on the schedule, even if they have to file it as unknown and later come back and update it after they've gone to trial. That is a fine thing for them to do, but they need to do it timely. They need to sort of make sure that the trustee knows about the claim if the 351 meeting hasn't happened. Certainly the plaintiff lawyer can call the trustee and they may not know that. Then on the flip side, the trustee needs to know what kinds of questions to be asking of debtors. Like Mr. Swope talked about, a lot of the times the debtor is really kept out of the loop. So it takes like the poking and the prodding, and that's one of the things on the checklist that we're going to provide to all of you, to arm your trustee with all of the kinds of questions to be asking of the debtor to try and reveal whether or not there is a bad faith claim to pursue. And then the other thing to do is ask the debtor to give you, the trustee, and then you counsel for the trustee, a copy of the insurance policies, so that you can sort of understand what's at play relative to what Mr. Swope was talking about, whether it's a first party case of homeowners or whether it's the business who's facing a CGL exposure. And so all of that happens right at the time when the debtor's filing the bankruptcy. Some of the forms that we're going to give to you are for the panicked underlying plaintiff lawyer who has never filed a motion in federal court and bankruptcy court before, but really wants to be able to go to trial and pursue their judgment against the debtor. The motion for relief from stay, the order granting relief from stay. There's some good language in there, excuse me, to make sure that the judgment that's obtained in that underlying case doesn't really limit the plaintiff to just collecting the policy limits, because the insurance company won't hesitate post-final judgment to come in and say, oh, look, this relief from stay only permitted the underlying plaintiff to collect the policy limits, no bad faith claim here. They'd be happy to do that if the order isn't drafted just correctly. So then you move to after the bankruptcy filing time, and after the underlying case has gone to final judgment. That's the time to hire have the trustee hire special counsel. The bankruptcy court has to approve the contract. That's the time to get that waiver from the debtor that Brent talked about. As soon as all of that is done, then all of a sudden special counsel can file the bad faith claim and move forward with it. And I guess one sort of final point where the underlying plaintiff lawyer can get trapped is in the language of the final judgment. You want to have a standard final judgment. You don't need to change the language in it just because there's been a bankruptcy filed. The judgment can still say for which sum let execution issue. That doesn't mean that you're then going to go start collection efforts against the debtor. The plaintiff's lawyer should and can be told that that isn't going to happen. The bankruptcy court will hold you in contempt of court, but that doesn't mean the judgment shouldn't be in the standard form, because now the bankruptcy trustee will take that judgment and pursue it like any other judgment. And I should mention this too, if settlement becomes a possibility, whether it's post-judgment after the tort trial or whether it's far down the road in the insurance bad faith case, there are those settlement considerations under Justice Oaks. And the bankruptcy court is the one who's ultimately going to have to approve settlement. So that's kind of a check and balance to prevent the incident that we were involved in, where the insurance company reached out to the bankruptcy trustee and tried to settle the claim for pennies on the dollar because it didn't really meet the Justice Oaks factors. So, thank you guys so much for your time today. We're happy to share with you the PowerPoint slides that we've put together. We have put together a checklist that we've laminated and hope to mail out to everyone to sort of walk you through the mechanics of it all. Thank you very much, Andy, for the time today. And thank you, Judge Vaughn.
Thank you all for a great presentation. We really appreciate you guys being here. We will post the recording of the CLE on our website for our members, as well as the PowerPoint presentation. And I believe we'll be circulating the checklist either by email and or by mail. So thank you very much. And with that, we'll be adjourned for today. Everyone have a great day.
Thank you, everyone.
Thank you.